Another, I have criminal appeal. It is long pending case since the date of 19. We both parties, respondent and appellant, have already submitted written arguments on this in the year 2023. It may be also in the first week of January.
First week of January. Argument here, sir.
6 January.
6, must have.
With your lordship due permission, I beg for listing of a criminal petition filed day before yesterday. The next date in the lower court is lordship 16th of December. So kindly allow me.
No. Revision petition will come in the.
No, this is
month of
criminal
January.
petition, lordship.
Yes.
I filed it day before yesterday,
Criminal
so it will
petition.
come in motion, lordship. So very urgent because 16th December is there at lower court, Tinsukia.
What kind of urgency?
That is quashing, for quashing.
For quashing, what is
Yes.
the urgency in quashing? Are you appearing?
Yes, appearing.
What is the stage? Shasmin?
No, lordship, it is a search,
At the
hearing
stage
on
of charge.
search, yes, lordship. So therefore,
You can take
urgency is there.
adjournment. No, next year. You can take one adjournment because next week it is very difficult. Already all the docket is full.
Tomorrow, lordship, because I have filed it the day before yesterday.
It's okay.
It will come in motion.
It's a criminal petition for quashing. It's not it was a case.
Lordship.
6 January.
May it please, my lord, prayer for listing of a bail application matter, my lord.
Okay. Motion stage.
Motion stage tomorrow, my lord. Please, my lord.
No, not tomorrow.
On 16th.
17th.
17th.
Deeply obliged.
Yes.
My lord.
Yes.
This is a criminal petition, my lord. My Zimma prayer was rejected, madam. Although my lord case is in trial stage, trial is going on, and my lord the person is in bail, madam. Our Zimma of the vehicle is rejected, madam. Only
January. No.
8 January.
8 January. Vehicle, not a human being.
May I please the
Next week
lordship?
we'll have to consider petitions of human beings only.
May I please the lordship? Already I have, criminal petition has been filed 11/11/2025, lordship. The matter has not been listed, lordship. So matter may be come up for 15 December, lordship.
Criminal petition.
Yes, lordship. Quashing of FIR and SARSIL, lordship.
At which stage? Argument stage.
Yes, lordship.
Argument stage.
Arguments, I do not know about that. My friend is also.
No. Maybe January. You must tell me the stage.
Lordship
that-
already 11/11/2025 I have filed, lordship. Matter has not been come, lordship. Before this honorable court, lordship. That is why,
11,
My colleague is-
2025.
yes, lordship.
No. 11/11/2025, only few days back. We will fix it on January, first week of January. Criminal petition.
7 January.
You are on bail, no?
Already 16 days fixed for
You
FIR.
are paid. You are on bail? Your
I do
client
not
is
know
on
about
bail.
that, lordship.
You must.
He also informed me to mention the matter before your lordship court,
Otherwise, you can come tomorrow with the motion. You bring the details, then I'll consider.
lordship,
You drop your motion today, you bring it tomorrow,
lordship.
okay? Then you bring the details. Everything must be in details, then I can consider if it's urgent.
Highly obliged, lordship.
May it please your lordship, I beg to mention item number 1. We have filed an additional affidavit, so let that be brought on record and the matter may be heard after some time. And lordship, I also,
Item number 1.
item number 1. Lordship, I also beg to mention item number 17. CD has not come and the petitioner is on interim, so that interim may be extended and a date may be given after due vacation.
CD is not received.
CDS corporation.
Item 17.
17?
17.
CDS corporation not received reminder list the matter on
1st January.
interim orders shall remain in force till then. Okay.
I'm deeply obliged, Lord.
May I please, your lordship, I beg to mention for a listing of a criminal petition on 17 December, lordship. Lordship, there is another connected case on that day.
Connected case.
Yes, lordship.
Are you sure? Connected
Yes.
case.
Obliged.
May I please the lordship, I beg to mention one criminal appeal from jail, my lord, to come up for order on 17 December, my lord.
Why?
With
Order? Why?
with IA, my lord, IA for bail, my lord.
Under which section?
Yes, my lord.
Under which section? Punishment under which section?
It is under section under section 376, read with section, I have forgot, child labor prohibition act, my lord.
May it please lordship, I beg to mention listing of a BA lordship. Matter was left over on 5/12 lordship, and the petitioner is in custody for 70 days lordship.
Under which sections?
64 gang rape, Lordship. Yes,
For 70 days.
70 days, yes, Lordship. Lordship, a matter may be fixed for tomorrow, Lordship. It was left over on 5/12, Lordship.
Next week of date of the video.
On the 17th December.
17 December.
Lordship, kindly tomorrow, Lordship.
No, not tomorrow.
May it please your Lordship, I beg to mention item number 19, Lordship.
Hmm.
CD has not received, Lordship. Interim is there.
CDS call for is not received, issue reminder, 19 days. Please the matter, 22nd January. Meanwhile, interim order shall remain in force till the next date of listing. 22nd January.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention list IA criminal. It is listed on 6/11. Now, in several times it is listed, it not heard the matter, last 4 times in the mention before the Lordship. So kindly, in a short date, list the matter. If it is possible next week, 6, oblige.
May I please, Your Lordship? Lordship, I beg to mention item number 27. Actually, the learned conducting counsel of the petitioner is currently out of session. And so Your Lordship may please fix the matter shortly.
You have taken consent from the other side?
Yes, we have
Other
taken.
counsel, Mr. Your name?
My name is S. Basak,
As Basak,
BSK,
on behalf of
A. Bhattacharya.
Learned Counsel Mr. A. Bhattacharya, with the consent of the other side as paid for adjournment, list the matter on
6th January.
6 January.
Much obliged.
May I please, Your Lordship?
Mhm.
Lordship, praying for listing of a motion matter by tomorrow, Lordship. If convenient.
What kind of motion? Bail?
AB, Lordship.
AB? No, not tomorrow. Next week.
17th December.
17 December.
Monday, Lordship.
17th.
May I please, Your Lordship? Lordship, I beg to mention for listing of criminal petition on motion, Lordship, on, it may be on 18, Lordship. Kindly, please.
On 18, criminal
Yes.
petition for motion?
Yes.
No, not on 18. 7 January.
Lordship, because the learned, this case has been fixed before the learned trial court on 26th of December.
What, you can take an adjournment? For what purpose?
Lordship, for Lordship trial.
Trial,
Yes, because,
evidence,
no, Lordship,
framing of charge.
just framing of such,
You
Lordship.
take adjournment
And
one day.
Only
How
the,
old is the case? How old is the case?
Lordship, it is started since the month of, Lordship, this is the second date that is
No,
going to be listed.
next week, next year.
19,
6
Lordship.
January, no. No, you are on bail, no?
No, Lordship, I mean, anticipatory bill from this honorable court. But someone has been received from the honorable court, but in the last date, Lordship, I have taken time because I have preferred this criminal petition before this honorable court. The entire process, when the petitioner has been enlarged on anticipatory bill, that it was noted that all the documents, all the evidence are documentary and there cannot be a process of criminal law, Lordship, criminal jurisdiction, Lordship. Therefore, Lordship, this is a civil dispute. It cannot be continued and go for trial.
You are on anticipatory bail,
Yes, sir, Lordship.
made absolute
It may-
or
absolute-
interim?
No, absolute. Lordship.
No, next year, 6 January.
Hello, please.
May I please, Your Lordship? Lordship, the one bail application, Lordship, a 4 month behind the bar and the 21%, Lordship. And last listed on 28/11/2025. And it is the 28/11/2000
POSCO or
leftover.
NDPS? POSCO or NDPS?
302, Lordship, IPC,
4 months.
yes. This are
Legal
case.
case, legal.
Next date, any date, yes, obliged.
May I please? I beg to mention for listing criminal petition matter. I am appearing in this lower court, my lord. And suddenly 2-3 days I was absent, my lord. Warrant has been issued, my lord. For recalling this warrant, I have filed this criminal petition, my lord.
Next week of DD.
Next date is, my lord,
18th December.
18. Can it be 17? Obliged.
Lordship, I beg to mention item number 33. May it be adjourned for the day and preferably fixed next on 27th of January.
Learned Counsel, Mr. Your
P.
name?
Dev Chaudhary on behalf of Senior Counsel Z. Kamar.
P. Chaudhary.
P. Dev Chaudhary.
P. Dev Chaudhary on behalf of Learned Counsel, Senior Counsel, Mr. Z. Kamar, with the consent of the other side.
Yes,
Has prayed for adjournment, list the matter.
27th January.
27. Obliged, mother.
May I please, Your Lordship? I beg to mention for the listing of a criminal appeal, Your Lordship. The IA is pending. It's for the orders, Your Lordship. So the matter may come on Monday, Your Lordship.
Why? Why on Monday? You are behind bars.
Yes, Your Lordship.
For how many years?
For 5 to 6 months, Your Lordship.
What is the term of punishment?
7 years, Your Lordship.
7 years. You are behind bars for 5 years.
Yes, 5 months, Your Lordship.
5 months.
The IA is pending, Your Lordship.
January dated a detail. On January, in the month of
Your
January.
Lordship, before vacation, if possible.
You see, it won't be possible. It will be a futile exercise because they will raise objection 7 years. Then we will call for the LCR. It will be a
Lordship,
futile
any date
exercise.
before vacation, any date.
Do we have the LCR with us?
Yes, Your Lordship.
No point. We can only increase the number of cases. We can give you a date before vacation. Did you?
On 19 December.
Much obliged, Your Lordship.
May it please your lordship. Your lordship, I beg to mention for listing of a criminal petition in the orders column, your lordship.
When?
Your lordship, tomorrow.
No, not tomorrow.
Your lordship, I mean Monday, 15 December. Can it be listed on 15 December?
What
your
is the
lordship?
matter about?
Your lordship, the matter is about regarding the Zimma of a vehicle.
No way.
6 January.
6 January.
May I please, your lordship? Lordship, I beg to mention item number 13, lordship, 1-3. Case diary was called for, but possibly it is not before your lordship.
Yes, there is call for not received. Issue reminder, list the matter on. You are on interim bail.
No, lordship. It's a criminal petition, lordship, for quashing,
Petition for quashing.
Oh, okay.
6 January.
6 January.
lordship. Much obliged.
May I please, Your Lordship?
Yes.
Should be back to mention on it, my lord. For that matter was earlier mentioned, my lord, but it was not listed into the court, my lord. In the lower court, the case is fixed on.
What is the matter?
It is a allegation of, it is question petition, my lord. And
Question petition?
question-
Which stage is the trial?
it was appearance stage, my lord.
Appearance stage.
Appearance stage. LCR is here, my lord, but it was listed, it was mentioned last occasion, my lord, but the mention was not,
You are on bail, no?
my lord.
You are on bail.
Bail, my lord.
You do not want to appear.
No, I want to appear, my lord, but the,
Okay. What happened?
but my
NBW
lord,
has been issued.
my lord,
NBW has been issued.
no, nothing, my lord.
January.
On 8 January.
8 January. Not tomorrow. We have to do 8 January.
I have some problem.
You see, we have to accommodate so many people. And we are yet to cover another 1 week. No, 10 days. Yet to cover another 10 days, maybe more.
May I please? Lordship? Lord, item number 20 and 21. We have Lord checked out, Lord. Notice upon the private respondent is awaited. Now I have been told, Lord, they are avoiding the Lord notice. Now I will take fresh steps, Lord, as well as Lord, if your Lordship permits, Lord, through the Lord OC, Lord, concerned police station. I will take register as well as the Lord other mode, Lord, if Lord learned PP is
20 and 21.
yes.
Learned counsel, Mr. M.U. Mondal is present for the petitioner. Learned additional PP, Mr. MP Hussain is present for the respondent state. It is submitted by the learned counsel for the petitioner that the respondent is avoiding to accept notice. Respondent number 2 is avoiding to accept notice. Full stop. The petitioner may take steps to issue notice to the OC of the concerned PS. Okay. Yes. OC of the concerned PS. Okay. And anything else?
Both item 20 and 21. Similar. Diplomacy.
To issue notice. The respondent number 2 available within 4 weeks.
Obliged.
Item 2 for motion.
May I please, your lordship? Lordship, this revision petition is arisen out of the judgment and order dated 4/7/2025 passed by the learned session judge Udalguri, whereby the session judge upheld the trial court conviction order dated
You were
30.
punished for how many years?
It's a motor vehicle accident case, lordship. Not more than 7 years, lordship.
No, what is the punishment?
Punishment, my lord. For the section 279, it's 6 months. And 6 months for under section 338. And 1 year and fine of
Okay.
rupees 10,000 for 3048.
We'll admit it.
My lord, kindly come to the page number 44 of the judgment and order of the trial court.
Why, you want us to stay?
Yes, stay, Lordship.
We grant it.
Yes, Lordship.
Learned Counsel, Mr. A. Das.
Ad hoc, Lordship.
Ad hoc.
Yes, Lordship.
Ad hoc is present for the present for the applicant.
বেলত আছে না?
He is not on bail.
Not on bail.
But I have filed another application, IA, Lordship.
No,
Prior person first.
for the applicant, Sri Pankaj Sharma, who has filed his application under section 38, read with section 442 and 528 of the B and WS 2023, challenging the impugned judgment and order dated 13/3/2025, passed by the Chief Judicial Magistrate Udalguri in PRC number 426/2022, within bracket GR case number 308/2020 bracket close, convicting the applicant under section 279, 338 and 304 A of the IPC and sentencing him to undergo rigorous imprisonment for 6 months under section 279 IPC, rigorous imprisonment for 6 months under section 338 IPC, and rigorous imprisonment for 1 year and fine of rupees 10,000 under section 304A IPC. Heard Mr. MP Goswami, learned additional PP for the respondent state. The petitioner has submitted that the petitioner is behind bars as he has been forwarded to custody. You are praying for previous bail, you are not behind bars.
I'm not behind the bars, Lordship.
Oh.
He
The petitioner submitted that the petitioner is already on previous bail.
বেলত আছে, বাহিৰত আছে না?
I am not on bail, Lordship. Lordship, I was under the bail when the trial court granted conviction, and accordingly, I have filed the appeal before the session judge. Session judge upheld the trial court order, and thereafter we have come up this revision before this honorable court, Lordship. And therefore, I have filed another application that is numbered as IA for suspension of the
Yes,
sentence.
suspension of sentence.
Yes, Lordship.
But here, my lord, you said then he is on previous bail.
You are praying to stay, remain on previous bail.
After the
I can allow only previous bail.
Session judge-
Yes,
Your
the
prayer.
previous will will approach the.
The petitioner has prayed for previous, petitioner has prayed to remain on
Standard
previous
case.
bail.
মানে করা না
Submitted now, the petitioner has prayed to remain on previous bail.
কেউ বাহিৰতে আছে না?
বাহিৰত আছে।
Session, let's see the session judge what order, my lord. Then
Otherwise,
it
we
will be
can,
clear, my lord.
extend till the next day, till the record comes,
Lordship.
Yes,
because
And we have.
what is the order for the session judge?
that is
Session
what
judge.
page
Last
70.
order,
Last order, Lordship. Page number 97, Lordship,
to
last
suspend
one,
the
last portion of the
portion of the
judgment.
impugned, aforementioned impugned, sentence and conviction, order of sentence and conviction. Operation of the impugned, order of sentence and conviction, aforementioned. Page?
Page number 97, Lordship. The last portion of the judgment, Lordship. The session court did not observe that the petitioner should surrender before the trial court. But in the meantime, we have approached this.
You can undergo simple evaluation, but 3 years.
Same.
That is, judgment is upheld,
Upheld, Lordship.
meaning thereby, my lord, he should
Same.
serve out the sentence. Now he is, my lord, perhaps
There's some
On the
irregularity.
irregularity. On July, this order is passed, my lord.
Yes.
Now it is December, my lord.
The delay was condoned, Lordship.
Delay was condoned,
Delay
but
was
the
condoned.
person is, he has not complied with session judge perhaps order, my lord. He has to surrender if it is, or otherwise he has to file on time, my lord.
And my lord, we have very strong ground in this case, Lordship. We may succeed in this revision petition. And kindly, why I am.
You change your prayer. You
Previous-
change your prayer.
It cannot be previous bill.
You are not on previous bail or anything as such.
Praise bill, my lord.
They will file a previous bail, direction may be given to the session judge, learned trial court, we may be allowed to. But when the appeal is dismissed, Lordship, it is not maintained for
You
the.
suspend the sentence, what to do?
Other thing, madam, they let him appear and prayer for praise bail in the trial court. Suspend the sentence and pay. Otherwise,
That will be better.
yes, because this petition is because petition is because will not be my lord proper because
It is not proper, a typographical error is there, Lordship, and that is admittedly I am submitting, Lordship.
Otherwise, you can correct it and we can fix it tomorrow, day after tomorrow. Or maybe on Monday, not tomorrow, but on Monday. Or else I can pass an order, it will be better to direct you to appear before.
Direct him to appear before the and prayer for face bail.
And in the meantime, a direction may be given, my lord, that bail
What?
may be allowed, bail may be allowed, Lordship.
I'll have to think over it. Let me think over it.
Lordship,
I'm not finding a way out.
Yes.
If you are,
and Lordship,
easiest way will be, see, I cannot find any solution to your problem now. Easiest way will be to amend a prayer. Otherwise, let's see, we'll find out a way.
Lordship, my prayer is that.
That will be in the afternoon.
My prayer is that Lordship
See.
may allow the.
See, I am also suggesting you, easiest way will be to amend a prayer. If you want, you amend it. Otherwise, if you do not want, then we will find a way out in the afternoon.
Can it be
You
fixed?
will let us hold this for some time. We'll get a solution. We'll have to ponder over it.
I will.
Immediately, we cannot.
Pisot matibo. Yes, to.
Hmm?
I'm telling him, Lordship will inclined to take it some time.
Yeah,
Fix that too, I
not 2 years.
Not at
Lordship,
those my list may perhaps expire. And as a last item.
Okay.
I will correct it in the meantime, Lordship. I may be allowed to correct it, Lordship.
It is fine here. Now that
Yes,
we have the
Lordship.
notification, no, can you correct with his hand?
Yes.
That's clear.
Lordship.
I don't think
I am
so.
not sure whether it can be corrected in by hand. Because-
Waste the time of the others.
Yes, Lordship.
Let us come up with the solution at in the afternoon.
Lordship, Lordship,
as a last-
We will also ponder over it.
Lordship,
We will also ponder over it.
Lordship, Lordship.
as a last item, logo.
Item 3.
Even.
Please, Your Lordship. In this case, Your Lordship, I have filed this petition for quashing the affair and proceeding of PRC case number 605/2024. In this case, Your Lordship, petitioner is not named in the affair, but they are the owner of the of the Buffalo series. Buffalo already ceased, but the case is registered and charged under section.
See, there is already an order at the motion stage, 10/11/2025. Already an order.
Already an order.
The Learned Counsel for the buffaloes are 20 buffaloes were seized in Kannauj. Buffalo
PCR call for and
requisition the aforesaid scan copy of the concerned. Okay, we do we have the scan copies?
Scan copy is there, madam.
receive it.
Otherwise, the case is fixed for in the appearance stage.
Hmm.
He is an absconder in the search sheet, my lord. Let him appear, my lord.
No,
There,
no,
my lord.
I have-
Because-
Filed this for quashing, Your Lordship. This process is already covered by the judgment of this court. I have annexed this judgment, page 26. That the buffalo is not in the schedule of the Assam Category Judicial Act, Your Lordship. Not is prohibited anywhere, Your Lordship. And that's why it is, on the page 26, I have annexed this judgment and relevant paragraph, Your Lordship. Page 13 onwards, Your Lordship. 12, 13.
Please read it.
The reasons were assigned by the learned court below for framing charge against the petition under 13(1) of the Cattle Preservation Act,
From where are you reading?
page 30, Your Lordship.
Page
Paragraph,
30, which paragraph?
paragraph 12.
Okay. Hmm.
The reason for assigning the learned court below for framing charge against the petitioner under section 13 of the Assam Cattle Preservation Act 2010, in spite of the word buffalo not being there in the schedule of the act, left this court miss unimpressed. It is to be mentioned here that an extended meaning cannot be given to the word calves, while the word buffalo finds no mention herein. Undisputedly, the Assam Cattle Preservation Act 2010 is a penal statute. A statute enacting an offence or imposing a penalty is to be construed directly. Strictly, clear language is now needed to create a crime. In a criminal institute, one must be quite sure that the offense charged is within the letter of the law. In the case of so-and-so reported so-and-so, it has been held that if two possible and reasonable construction can be put upon a penal provision, this court must lean towards that construction which exempt the subject from penalty rather than the one which imposes penalty. It is not competent to court to state the meaning of an expression used by the legislature in order to carry out the intention of the legislature. It is also well settled that an enactment is a penal provision is in itself a reason for hesitating before ascribing to phrases uses in its meaning broader than that they would ordinarily bear. Reference in this context so-and-so decision is so-and-so. Since herein this case, Buffalo is not incorporated in the schedule, this court is a view that an extending meaning cannot be given to the word called first to incorporate Buffalo called therein. While state construction is required being an act is penal institute is held in the case of so-and-so, the court has to lean towards the construction which exempt the subject from the penalty rather than one which imposes penalty. In view of the discussion and findings was arrived at this hearing above, the impugned order so-and-so so far it relates to framing of charges under section so-and-so 13(1) of the Assembly Act 21.
Charges have been framed in your case.
No, it is cognizance has taken.
But here you are asking for custody of the cattle.
No, I am quashing for the proceeding.
Okay.
Because every procedure of there is no, Your Lordship, because we are the owner of the cattle. We have filed Zimma rejected, that is another thing.
Okay, yeah, I think can be stayed, I think.
Yes, my lord, but also kindly say page 31 last part,
Page
my lord.
31.
For the learned court, ordinary defenses held, my lord. It is stated that last paragraph 15, my lord, page 31.
Clear that setting aside the impugned order, so relates to criminal charge and so-and-so assembly there. Against the president will not stand in any way proceeding against him under section 317 of the Assembly.
Other sections are not quashed, my lord. Only 13(1) is, my lord, quashed, my lord, and against, so far the language is.
Language.
317 and 411 is not quashed.
Not quashed, because I am the owner, I am the proprietor, I have purchased the cattle, because there is one thing, at 379, we have to.
We can stay, I think.
We have to settle, we have to.
Or you have any objection?
Yes, my lord, because there's, otherwise, my so far decision he has been relying on, my lord.
No.
It stated that only cattle like because of the buffalo, my lord.
It's a similar order.
Similar order. If you-
Without
Lord,
staying,
can-
we'll pass a similar order.
There is not state, my lord.
370, we have to verify the record.
Quash the cattle trespass section, but other sections will not quash. We'll pass a similar
Because your
order.
lordship,
Yes.
can see 379, we registered section, we are the owner of that, there is no. We have the owner of the.
79, 411, we will not stay.
There he can face the trial.
That,
No, already that, on
Four-
that day, your lordship.
you see 528,
Lordship.
I cannot consider the evidence. I must only consider the prima facie case, and we have the LCR.
And
So-
that's why LCR has called that, on my submission, there is LCR part, we are the owner. Court has asked the, called the LCR because verify that part only.
So even if the LCR comes, I will not deal with all this evidence at under section 529. Oh, sorry, 528.
379 and.
528, you are filing under section 528.
I
You
think.
will not deal with evidence. Evidence will be dealt with by the trial court. Then I'll quash only that trespass act according to his order.
No, sir.
Similar order.
Hmm?
Similar order.
Similar order I'll pass. Then I'll dispose it off now.
No, sir.
Heard learned counsel Mr. S. Islam for that. Petitioners, Monul Haq,
Three petitioners.
Sainal Haq, Yanu Islam Akan, who have filed this thing, who have filed this application under section 528 of the BNWS 2023 with prayer for quashing the FIR the entire proceeding of PRC case number 605/2024 in respect of the petitioners. To stop the PRC case has been registered on the basis of the Salmara PS case number so and so under section so and so. Third, Mr. MP Goswami learned additional PP for the respondent state. Full stop, the learned additional PP has accepted notice on behalf of the respondent number 1, and thus no formal notice is required to be issued. Full stop. The learned counsel for the petitioner has relied on a decision of a coordinate bench of this court in criminal petition number 601 of 2022, where invite order dated 19/5/2023. The proceedings under
13(1)
uh,
and 6.
13 within bracket 1 of the Assam Cattle Preservation Act 2021 has been stayed.
Set aside.
Has been set aside,
That's
has been set aside and quashed. Full stop. It is submitted that the present, the case of the present petitioners is a similar case as the allegation against the petitioners is that
FR is not named, but in charge sheet they have certainly their name. FR page 12. Page 13 years.
they are guilty of smuggling buffalo. Huh?
That's
They are guilty of smuggling buffalo. 20
numbers years.
20 heads of buffaloes. Hello, yes. It is submitted that that buffalo has been exempted from the purview of the Assam Cattle Preservation Act, 2021. And as regards the other charges, i.e. under section 379 by 411 of the Indian Penal Code, there are no materials in the record. Full stop. It is submitted that the petitioners being owners of the cattle.
Cattles.
uh,
They are
owner-
out of 20, they are 12. 12 cattle. They are owner of 12 cattle. There's some other person, so they are 3
that the
petitioners have
petitioners being owners of
12 number of
12
cattles.
cattles out of the
26 cattle.
20 cattle
buffaloes,
in
buffaloes.
connection. Huh?
See, 26 buffaloes case,
Or 26
buffalo.
buffaloes, 26
20,
out of 26, out of the 26
two,
cattles
out of
allegedly-
20s, they are 12.
Huh?
Out of 20,
Huh.
they are the owner of 12 cattles.
Six. Out of 20 लिखी but 26 ना like out of 20 they are the owners of 20 heads of cattle out of the total allegedly smuggled 20 heads of cattle within bracket buffaloes, bracket close. Charges have been framed.
Charges not, yes.
Yeah, Cognizance has taken, charge not framed, page 33.
It is
Cognizance-
submitted that the cognizance has been taken under section 13(2) of the Assam Cattle Preservation Act
13(1) and
2021 within bracket the Act of 21 for short, and under section 379, 411 of the IPC. Had order dated, have you annexed the order?
Lordship, page 23. 30/10/2024. 30/10/2024.
There was the
Page 23.
paragraph 10, my lord.
Hmm.
Paragraph 10 of the judgment, my lord. It's something yet to be. That will not continue.
Like this.
13(1)/16 detail
Ten
लिखा, हाँ?
percent, it is-
Cattle trespass. 13 within bracket 1 bracket close stroke 16. Yes, judgment of paragraph 10.
Yes, judgment paragraph 10 of the judgment, my lord, relying on it. 29, page 29, paragraph 10.
Male and
However,
female buffaloes.
Yes,
No, it is earlier, Your Lordship. It is 1950. From page 29, Your Lordship. Earlier it was there. Before amendment, yes, sir, cattle preserve-
So you can smuggle cattle, buffaloes, no?
Not, but they are for businessmen.
One can smuggle buffaloes.
Buffalo is allowed, not restricted, Your Lordship. Buffalo is not restricted.
Earlier it was there.
First it was, first.
In
there is a-
1950 Act, it was there.
actually
Available
restriction was there,
restriction
madam.
is there, but in New Act.
New
they
Act,
do not
how
allow
can,
it.
that is why.
And here charges are framed under 2021 Act.
Yes, charges have been in 2021 Act.
So buffaloes are excluded.
Excluded.
Let me see the book.
It is there.
So this is the amended Act.
Amended Act.
So charges will be framed under the amended Act.
Amended Act.
It will not be framed under the old Act.
Because
No.
case is registered earlier years. Because case is registered in the IPC earlier years. Case of FIR of 2024. Oh, that's
It will be there.
there.
FIR 2024, then it will be.
New
Where-
Act.
Where is the FIR?
FIR ownership page
On the
13.
back page, we will get the Act,
13.
Yes.
page 13, no?
Yes.
The magistrate has not mentioned the
Not,
year of the Act.
yeah, not mentioned.
So let's see the FIR, then we will get to know under which sections it was listed.
13, yeah. Not mentioned.
Nowhere it is mentioned,
Mentioned, not mentioned.
but it will be 21.
Yes, it will be 21 Act will follow. Yeah, it's a case of 24.
In charge sheet also not mentioned. Only ACP mentioned.
That's framing order will be 23, no?
23. Then, next to the-
Hmm.
Professor Pala.
And while charge framing charges also, madam, only ACP Act. No,
We are not mentioned.
Yes.
year not mentioned.
The learned counsel for the petitioners has relied on the decision of this court in criminal petition number 60 or decision of a coordinate bench of this court in criminal petition number 601/2022 in the case of Mofizul Haq versus the state of Assam and another wherein by order dated 19/5/2023, it has been observed that paragraph 12
Well, 13 also.
paragraph 13. Italics of likhi diba, next paragraph. Reverting back to this case. But charge was not framed, no, so what to do? Charge was not framed.
Charge frame also.
Proceedings under section is what, but that proceeding under that will remain in.
Yes, madam. Because the charges are framed, madam.
In view of the foregoing discussion, this court deems it appropriate that the proceeding of PRC case number it will be diba,
So far relate to madam charge under section ACP Act can be stated.
not charge.
Madam, cognizance.
Proceeding.
Under proceedings of so and so PRC case number under section 13(1) of the Act of 2000.
1 and 16.
Uh.
And 16 also. 13, 1 and 16.
16, I do not know. We'll have to check 16.
16 also similarly order.
Let's see.
Charge frame by madam.
That's.
Charge is not yet framed, madam.
No, cognizance.
Cognizance.
Okay, attempts and amendments. No, not charges, not only proceeding.
Yes.
Cognizance.
Only
taken
proceeding. So, right.
Proceeding
Perhaps my-
section 13(1) and 16 of the Act of 2021, so far as the proceedings under section is concerned, comma, the proceedings are proceedings under section consequence and nalage are set aside and quashed, but comma but this case will proceed under section 379/411 IPC.
Yes.
The order of cognizance under section 13(1) of the Act of 2021
trial
So 16 or 13, 1 and 16 is hereby set aside and quashed. Whereas this case will proceed under section 379, 411 IPC.
Actually, this period, it decided by the trial court already. You directly said that it is proceeding because if there is no
No, no.
evidence, if there is no evidence of that 379, we'll,
Okay.
at the time of
Yes,
instance,
yes.
we'll discharge petitioner.
Proceeding will continue. Proceeding continue.
Trial court will decide.
And the same issues may be raised by the same issue and the similar issues may be raised by the petitioners before the trial court at the time of
Framing of
huh?
charge.
At the time of framing charge.
At the time of framing of, this will be framing of charge, no? Yeah,
Yes,
at the
yes.
time of framing of charge. In terms
That
of
is-
the above observation, this petition stands disposed of.
Yes.
Huh? We'll take up later. We'll complete everything and then even I also have to think about it, so we'll take it up later.
Item 4.
Variation of joint decision.
The petitioner number 1 and 2 are husband and wife in this case, Lordship, and they both are paying for quashing the FIR of dispute PS case number 856 of 23, dated 15/5/23, registered under section 498A. Lordship, kindly see the FIR, Lordship. Page number 18.
Page number?
Page number 18, Lordship. 18, 1.
Yes, please read. No, video probably, what is? Family dispute, please read.
Lordship, the 11%.
Lakh, which has been paid to Jugal Sekia, hereby take back, give back, white check number so-and-so dated 29/11/24 and check number so-and-so dated 15/1/2000. So I issued 2 checks for payment of what? Payment of this 21 lakhs. This is what? This was the bill, cancellation. Now, thereafter what they did? They misused one of my check. They made it 31 lakhs. One check was entered by them as 21. I gave them blank check. It is admitted position. So they entered 21 lakhs in one check and entered amount of 10 lakhs, which was given by them to Sanjeev Das, and entered the amount in my check and misused the same. And they bounced us both the checks and sent me legal notice, demand notice, madam. Can you see demand notice in page 43?
So this is on the section 138 and
138 and 9.
Okay, page 43.
43.
Okay.
43. My lord found it.
Hmm.
Now this is it. Now, para number 1. That you have entered into an agreement for sale of land with my aforesaid client and his wife, Mrs. Nazima so-and-so, and you have received a sum of 31 lakhs. This is. So they have come with dirty hands. They are not coming to the court with clean hands. This agreement cancellation clearly shows that it was 21 lakhs. I gave 2 checks for payment of 21 lakhs. But they made it a different story. They concocted story. And now they demanded this. This notice was sent for recovery of 21 lakhs. In paragraph 3, it is written that in order to repay the aforesaid amount of rupees 31 lakhs, only which you have received as advance payment, you have issued 2 checks to my above noted client bearing so-and-so of rupees 21 lakhs and check number so-and-so 10 lakhs. This is false. This is concocted. Now, my lord, against this notice, I gave a reply, and reply is in page 47.
Okay.
Page 47 is my reply to their demand notice. So now, till now, what we have seen, that they have changed the story.
Mm.
Now, demand notice reply, this is, that I have received an amount of, please refer to the above, that I have received an amount of 21 lakhs. That was shown by the cancellation agreement. Only and not 31 lakhs. This was my reply. That rupees 10 lakh was paid to Firoz Chaudhary, to Sanjeev Das. This is admitted by them in that document. Now, this was my reply. Now, after that, even after receiving the reply, they went ahead with the case. Now, they filed two sets of case. One based on my first check, which they misused it by entering an amount of 21 lakhs, and second check, which was also blank, they entered in amount of 10 lakhs. So in spite of, in both the cases, against both the demand notice, I sent the reply. That is admitted. Now, even after that, they went ahead with the case. They filed two cases. One for 21 lakhs.
And then you were convicted in both the cases?
No, the irony is that in one case I was convicted, in another case I was acquitted. This is a conflicting situation where behind the background of same transaction, a single transaction on the same set of documents, there are two conflicting judgments standing before me. One conviction and one acquittal. Now, my lord, the thing was that the real thing, the main documents which is relevant here is Exhibit 6 series.
Exhibit 6?
Series 6, 61, 62, 62, 63, and 64.
Okay.
And the two cases were CR case number 380 of 2018, which is regarding 10 lakhs, no, 21 lakhs. And one is 892 of 2018.
Okay.
Two sets of
cases,
cases. They were going on simultaneously, but not in one court, but two courts. That's why this situation arose. Now, what is Exhibit 6? It is my reply notice, reply to their demand notice, which I have already placed before my lordship. Now, what is 6.1? 6.1 is the cancellation agreement, which I have already shown to my lordship. What is Exhibit 6.4? 6.4 is the money receipt with regard to payment of rupees 10 lakhs, which the respondent and his wife paid to whom? Sanjeev Das. And that is on page 56, my lord. Kindly see, my lord, 56.
So you are acquitted in one case, so you are not aggrieved by that order.
My lord?
In one case you are acquitted, you are not aggrieved by that order.
No.
So you didn't prefer an appeal?
We have prepared, my lord, against acquittal.
Oh, I'm notice person. They, because I was acquitted.
Let us bring that case also.
Oh, both can be.
Yes,
Hmm.
that can
We
Both
have
can
a
be.
case here.
Yes, it is pending here, my lord.
That will clear the entire situation.
So let us bring the case. We'll hear it together.
My sole contention before the appellate court was that to bring the record of that case to this appeal so as to give a substantial justice. So that was rejected.
Can be brought, I think, under section 33 of
No,
the
it can be done.
Evidence Act also. It can be
Definitely,
brought.
it can be done.
Same parties.
If this is done here, so everything will be settled. So that can be done. Case number 1.
It will liquidate. No, I think
We will provide the case number.
Okay.
We notice.
Learned Counsel, Mr.
Ji, sir, kya?
No, that much I wrote. Learned Counsel, Mr. Your name?
H. Ali, madam.
H. Ali is present for the respondents and has submitted that he has not received copies. Copies of the petition. It is also submitted at the bar there. another case arising out of the same cause of action, being case number how much? Criminal appeal number?
My lord, I will confirm it, my lord.
Criminal appeal number लिखित हो जाए confirm to do also is pending in this court. List petitioner to furnish copies to the petitioner to furnish copies list this matter after vacation day.
After vacation, date may be fixed, my lord. Date.
List this matter on
19th
along
of
with
January.
dot
Well,
case number.
Can it be on 21st of January?
Yes, can be. It will लिखिए दिया interim order shall remain in the next date.
Until further order, my lord. Yes. Because sometimes some situation arises, my lord.
Obliged.
Till next date of under further order.
Till
my lord.
next date, yes.
Obliged.
Mentioning item number 33, I forgot to mention that there is an interim protection in it. May it be allowed to continue.
Puna select. Okay.
Obliged, madam. Thank you.
Hey, please, your lordship, the engaged counsel is on lag in C16 as RSA hearing matter is going on. Kindly pass over the matter at 2 p.m. Obliged.
At 2, man. At 2.
Yes, at 2.
Or my lord will take it at 2 or will pass on for the day, man.
My lord, at 2.
You decide. Both of you talk.
Subject to your lord,
Discuss and according to
subject to your lordship
convenience.
convenient, man.
I don't have any problem.
Man.
You discuss it.
Man.
Item 9.
Obliged.
My lord, pass over this for the time being.
Pass over for time being.
But I would like to submit before your lordship. This has come to me after my appointment. I have gone through the 3 orders and I did not find any written or para-wise objection from the side of the CBI. So we need to file, because in earlier occasion, they have filed 2 applications which were rejected by this Honorable High Court. So that is why we need to reply.
Let us give them time.
Yesterday only I have come.
This case is stayed.
No stay is there. They want to get modify their conditions given in the bail, that whenever they will go outside, they will take permission. This modification they need. That is imposed by the Honorable Trial Court.
Item number 9, no?
Yes. So I may be permitted to file reply
Your name?
sometime.
Arcolita.
Learned Counsel Mr. R. Kolte is present on behalf of Learned Counsel Mr.
RK Moore.
R.K. Moore, representing the petitioners. Learned Standing Counsel in CBI, Ms. M. Kuwari has submitted for time to file
Reply.
reply. Parawise reply against the petition. List this matter on after 4 weeks or 3 weeks.
3 weeks.
List this matter after 3 months. Okay.
Item 10.
Right, please, Lord. In this matter, I am the respondent. I have filed an IA, my lord. The IA is for, my lord, interim compensation as per section, my lord, 143.
Before my
143A.
Yes, my lord, yes.
before my
Yes.
learned friend starts, my lord, there is a development, my lord. Perhaps, my learned friend is not informed properly, my
I have
lord.
been informed, my lord. There is no compromise, my lord. Last occasion, my friend personally called me and said that within 1 week it will be paid. But after 1 month, no discussion is there. And in the trial court also, my lord, they have assured that it will be paid. In the appellate court also, they are assured that it will be paid. And now, my lord,
Last chance, my lord, may be given. If not, my lord, with compromise not come before your lordship in a fixed date, my lord.
Then we will allow 143A.
No, my lord, this petition may be allowed, my lord.
Yes.
Order may be given.
my lord,
Next time submitting.
the
Yes, my lord.
submission,
Can my
Yes,
lord,
giving a condition.
my lord, if I am failed, my lord, then this application may be allowed, my lord.
Yes.
submission may be recorded, my lord.
Yes, my lord.
Yes. we
Yes,
record it.
Submission recorded and a fixed.
There's a last chance, my lord.
Fixed date may be given.
First week of
IA number 961.
961, my lord.
Yes, Ahmed?
MJ Kadir.
MJ Kadir. Learned counsel, Mr. MJ Kadir is present for the applicant. and
Respondent,
learned-
applicant. Applicant.
Yeah, okay, okay, okay.
Applicant
For
respondent.
the respondent applicant and learned counsel for the learned counsel, Mr. A.M. Borgue is present for the appellant.
My lord, a petitioner, my lord, present, my lord, opposite party, my lord.
For the petitioner,
The revision petition.
give the names. What is your name?
My lord,
What is the
his
of
name
the
is
client?
Bidan Chandra Rai, my lord.
He is present for Bidhan Chandra Rai likhi diye.
My lord,
बाकी को लिखना ना लगे, petition respondent लिखे लिखे। So it is submitted on behalf of
Bidan Chandra Rai, my lord.
Bidhan Chandra Rai that there is a scope of settlement, and in case the matter is not amicably settled, the learned counsel has submitted that the petition under section 143A may be allowed. Okay.
My lord, this IA, my lord, mention maybe, my lord, this IA, my lord. Interim IA.
This IA लिख दिया. This IA petition number ना लगे, this IA number, IA criminal number 961 of 2025 may be allowed.
Madam, not settled before the next date. Madam.
Yes, my lord,
Before the next date. That is mentioned, madam.
If-
Before the next
Before
date.
the next date, if not settled, my lord.
If no settlement, before the next date fix लिख दिया. Before the next date fix. List the matter on.
27.
You want a date?
Yes,
Yes,
Okay.
fixed date, madam.
Yes.
Of life.
The main case.
Main case, my lord, thereafter, my lord, date may be fixed, my lord, after 27, my lord.
If not settled, madam.
Yes. Diploma.
Item 11.
For now.
It is a 528 BNS application to set aside the order dated 4/6/25 passed by the special judge Sudalguri. They were rejecting the Jimma petition filed in connection with Rota PS case 5825 for seeking Jimma vehicle number AS01GE6322, Your Honor. Your Honor, the petitioner is the registered owner of the vehicle, Your Honor. And
We are waiting for a report.
My lord, report not received today, my lord.
Investigation.
My lord.
Is it at a stage of investigation?
My lord. I have no
Yes,
information, my lord. I have to for short date, my lord, for producing the
Short date when?
next, my lord.
Next
After
year?
vacation, my lord.
Your Honor, it's been
Vehicle,
204 days, Your Honor.
Vehicle next week, next year.
It is involved in the NDPS case.
See,
But nothing is recovered from the vehicle, Your Honor.
Huh?
Nothing has been recovered from the
Okay,
vehicle,
it's
Your
okay.
Honor.
It's okay. This last week, we are thinking of only considering the cases of human beings.
My-
Vehicles will consider later, next year. Okay. Report as called for is not received, we should amend it, list the matter on 7 January.
Item 12.
May it please your lordship, it's a question petition.
Mm.
And in this matter, the informant has appeared.
I'm for respondent number 2, your lordship. Matter has already been settled between the parties.
You have settled the matter?
Yeah, but virtue of an affidavit, I have no objection in regard. If your lordship pushes the petition, I don't have any objection, your lordship.
The entire matter is that all the family members, these are the informant was the wife of the accused number 2. Then accused number 1 is the nephew of the informant. Accused number 3 is the sister-in-law. Accused number 4 is the mother-in-law. So basically, maybe there was some civil dispute may have been there. But later on, what has happened? That transpired to the lodging of the FI. Heat of the moment, she went due to some influence of some third parties. If allowed, my lord, we'll go to the FI. If allowed,
Yes,
the FI in the FI itself.
Because it's the POSCO case, we'll have to go to
Yes,
the
yes, the FI. The FI is page number, lordship 18. And the translated type copy is page number 21.
Just a moment, we see. We have a recent judgment of the Supreme Court.
As an interim, my lord, what is the problem?
On the
See,
last,
I don't know, my lord.
last occasion also, my lord.
Matter on.
My lord, on the last occasion, personal appearance was given, my lord.
No, not required.
On the last occasion, it was ordered, my lord. For personal appearance of the IO, my lord. Last 7 times they have sent the CD, my lord. I am in the interim, my lord. I have already appeared before the IO, my lord. That may be absolute. That may be absolute, my lord.
My lord, last chance may be given. I will talk to my lord.
There was
Was I-
order passed by a court bench. I have not passed any order for personal appearance. as
No, no,
far as
last
I
occasion,
remember.
another 4, my lord.
Where?
24/11. 24/11/2025.
Which paragraph? Which paragraph? Personal.
Well, on
appearance?
last order, my lord. 24/11/2025. Order dated.
A coordinate bench of this court by order dated 24/11/2025 has directed personal appearance of the IO. As CD has not been forwarded, full stop. Learned additional PP, Mr. B. Sharma is present for the respondent state. IO to.
My lord, in the last order, my lord, it is in default submission of the my lord, for order I have not gone through, my lord. In the earlier order, what is?
There is an order for
My lord.
personal appearance.
If it is failed to produce the case, there is-
Yes, on several occasions, not in 1-2 days, my lord. 7 times we have failed to produce the CD, my lord. Therefore, the personal appearance of the IO was given, my lord. And already I have appeared before the IO.
Not in default. IO to positively produce the CD
my lord,
on the next date fixed.
My lord.
Down.
no, earlier.
No,
See, 5 or 6, five or 6, no,
View
5 or 6,
I'm not
5
there,
or
my
6,
lord.
my lord.
After view revision, my lord.
If they are claiming the after getting interim, my lord, CD not received, then 5 or 6, my lord, immediate
No, you
after.
are fixing, we will fix for before 6.
No, my lord, I will not be in this period. I am going for my cataract surgery of my eye. I will be on rest, my lord. There are 7 times that they have not produced this case. They cannot force it like this.
They are objecting that CD not received after getting interim, my lord. Then
No,
we'll
no.
put it on first week, my lord, January, first week of January, my lord.
Why did you submit for personal appearance then if you are not able to?
My lord, they are not. Why I am not? I am appearing, my lord. They could not file the produce the CD.
Next
to
day
the
you are
court, my
not
lord.
going to appear, no?
My difficulty is that, my lord.
Why the IO, he is also working, he is also duty bound. He is not sitting at home, he is also working.
Maybe, my lord. It is the court's order. I have not asked for giving personal appearance, my lord.
Without your submission,
I have submitted for granting absolute, my lord.
data the detail. Without the CD, absolute without the CD,
On 20, my
you are
lord.
so innocent.
On 20, my lord.
Section 64 is there.
On 20, my
Did-
lord.
20.
Lordship.
21.
Interim may continue, my lord.
Interim order shall remain in force till the next date of listing. Till the next date, till then लिखिए.
My lord, personal appearance order, it is dispensed or IO is active to produce.
Oh. The personal appearance of the IO is dispensed with.
My lord.
Item 15.
May I please your lordship, my lord? My lord, this is a pre-arrest bail application, my lord, and I am not on interim, my lord. Lordship was pleased to call for the CD, my lord, on today is the 4th day, my lord. The CD has not been received by this honorable court, my lord.
My lord,
My lord, I am praying before your lordship, my lord.
no.
For a moment, lordship will kindly have a look at the FIR, my lord.
My lord, it was also in the from the my lord, we have received one wrong information, my lord. In the morning, he said that it was my lord from Juria, my lord. Then we talked to IO and
Very nearest
state
police
office,
station,
my lord.
Juria and Jajuri,
But
but
it
not-
is found that it is Jajuri, my lord.
Nagaon, my lord. Both are from
No,
Nagaon.
Nagaon, but police stations are different.
Today is the 4th day, my lord. But why I am praying for a interim, my lord? For a moment, lordship will kindly have a look at the FIR.
Can I call for CD, my lord, reopening, my lord, there
Page 9,
already
my lord.
in the earlier it was
We are
rejected.
not named accused persons, my lord.
That is the even.
Earlier rejected, my lord. Lordship may kindly
Earlier
please.
rejected.
rejected, I understand, my lord, but I
And
why
if
I'm
not two, my
submitting
If you are not named, it becomes more difficult for us.
My
If you are
lord.
named, it's okay, we can consider something.
It is earlier
But if
rejected,
you
my
are
lord,
not
Lordship.
named, undercover.
Even then, I'm submitting before.
Page 11, my lord. Page 11, Lordship may kindly page the Lordship's order, my lord.
Page 11.
My lord.
Page 11 is the order, my lord.
Rejected, there's an
It
appeal
was in
it was
the
called for, my lord.
investigation stage, my lord. Page 12 is the, my lord, operative portion, my lord. There are 6, my lord.
See, no,
But that area
no,
is,
after
Lord.
considering the case diary
My lord.
rejected, we'll need the CD.
My lord.
You see, when there are materials, that even then I consider, and when I do
My lord,
not
since
consider,
today is
then
the
I
4th
think
day,
there's
my lord. That
something.
is why I'm praying for
If-
interim, sir, my lord. Some relief, my lord. CD,
My lord, 6th or 7th, my lord.
You have new grounds.
my lord.
Do you have new grounds?
New ground is that, my lord, that area, my lord. According to the FIR, my lord, the fish market fair, my lord, the commission of rape was supposed to be, my lord, alleged.
We will consider.
No,
after
no,
CD.
that is not the
Once
ground.
bail was rejected. Serious call for is not received. We should reminder IO to forward CD positively on Bihubisar Didio or Heribisar Didio. 6
6th
January.
January.
First day.
My lord.
Item 16.
What?
Item
Oh.
number?
Oh.
May I please, Your Lordship?
No. It is okay.
May I please, Your Lordship? 482 bail application. But case diary was called for. Earlier case diary was received, but on that day, victim's statement was not received.
You have the victim statement?
My lord, CD we have received, my lord. Here, as per my lord, IO note, my lord.
Hmm.
The injury is yet to be examined, my lord, as he is outside the state, my lord. He is in Kolkata at present, my lord. My lord, that's why it was not possible to, my lord, the statement of the injured, my lord. And,
We need the statement of the victim.
my lord,
We need the statement, I think.
my lord, it is the, my lord, he is the main person who know about the incident, my lord. He himself, my lord.
My lord, earlier, learned friend submitted that victim and the petitioner, between the victim and petitioner, there was a
Compromise.
no, my lord, some
Altercation.
words, yes, altercation took place between them. It is that part was revealed, my lord, but nothing was.
Lordship,
revealed.
kindly page the FIR, my lord. FIR, it was.
In the FIR, everything
what,
is
my
there,
lord?
my lord. But actual fact is, I have
No, 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 no.
To know the actual fact, he is the best person. my lord.
CDs received without the injury report of the victim.
Injury report received, my lord.
Oh.
But examination of the victim.
Oh, you have the injury report.
Injury report is.
Okay, what is the injury report? That's it.
Injury report, my lord. Here, my lord, grievous, my lord. And one fracture also found, my lord.
Okay, where?
Fracture in left second rib. In a anterior aspect, my lord. Lordship, may kindly page the medical report also, my lord. Everything. But he is the person, my lord, actual person who knew, my lord, who knows, my lord, about the incident. Whether he fell down or he was in altercation, he was assaulted, that is, my lord.
He fell down, that is why I got injured, my lord. But I did not assault him.
But
actual
Oh,
fact, I
no. Fracture on head. No, no.
fracture on head, but actual fact is I have
Fracture on
stated.
head.
Actual fact I have stated in my petition, that is paragraph 5.
You see how hard our skull is.
Yes, but I
If
have
you
stated
hit,
how he got the injured.
the impact has to be
But
great.
I have stated in the
Yes, yes,
my
he fell
petition.
down and got hurt. We'll come to know you're not behind bars.
But he fell down, but I did
Anyway,
not assault
right, isn't it?
him.
He's a police personnel, no?
Yes,
The
he's a
accused.
police. But he's not in.
So you see, he's
But-
not a juvenile also. He will know how forceful his
Madam,
impact will
Can
be.
you see, my lord, for a moment, my lord,
No, no,
Okay.
no. Police are not supposed to hit anybody.
or my lord.
Learned counsel, the parties are represented. CD is received without the statement of the victim. Send back the CD. Call for the updated
Updated CD along with the
statement of the victim positively, huh?
My lord.
Otherwise, he will also take
My lord. That is
all
my lord.
these for recording.
My lord.
Release the matter of 7 January.
Oblige, my lord.
Item 18.
May I please, your lordship?
Hmm.
No, the earlier honorable court was rejected the bail matter and subsequently I have
You
filed.
need
with
CD?
My lord, CD received, my lord.
Only on the ground that, my lord,
My lord.
informant and the present petitioner, they're the relatives, my lord. The present petitioner is the younger brother of the husband.
Hmm.
And my lord, she lost the affair. On merit, my lord, I cannot argue because once rejected. my lord.
Already earlier
And
rejected.
it was so many delay also in the affair. And my lord, what happened? She at present, my lord, executed an affidavit, my lord, that she is saying, page, my lord, 18, my lord, 18. Page 18 on 8 and then, my lord, in paragraph 3, my lord, that
I am appearing for informant matter.
due to misunderstanding between me and accused person, the case has been lost. And after filing the Ejahar, the victim, the veteran people of the locality has settled the matter amicably among us. I have no objection if the IO of the case has submitted final report. in connection with the above noted case and acquit the affair accused person, my lord.
This
And
is AB,
she
no?
filed the
AB?
ABM. And the other side also, if you are going to, she
It was
saying that.
earlier 2 times rejected by it.
No.
One rejected by the session judge on 17/2/2025 and here lordship on 7/4/2025 after going to the case diary, my lord. And 183
Well, it-
statement, her, my lord, statement lordship.
But the measure girl, my lord, merit very, my
Serious
lord. While
allegation is very
says
serious, my
thing.
lord. Allegation-
Whatever may be, but when it is not a case of acquittal.
Video off করে দিয়েছে না? পছন্দ ভিডিওটা? ভিডিওটা off করে দিও।
It is,
My lord, ultimately it is not.
I'm not going to
But
get.
our bench will not take, my lord. Generally, the honorable court is.
No, no. When I'm out of station, I won't be there.
Then
When I'm-
also, my lord, I
No,
have.
no, no. Nowadays they are taking up. You haven't got the new
But
notification.
Starting, my lord, I filed the application for through
Then
BC.
reject it. You. I'll
And
give you
Sashi
good
cannot
advice.
be-
You're not taking my
164
advice. I'll reject it.
164
আছে। সেইটোৱে 164 টোৱে কৰিছে ইমান বেয়াকে লিখিছে তাত।
You are not taking my advice. I won't be here at in the first week of January. Don't you know about the new notification? When the officer is out of station, sorry, when the judge is out of station.
Even then, my lord,
No, it won't come.
but once reject, my lord, the no court will
No,
consider. my case.
even reject it, you do not know about the notification. Notification on DVS. Why you're not taking my advice? I'm not lying.
No, that's fine.
From this chair, I won't.
No,
be
my lord,
lying.
I admit, my lord.
If you want a rejection order, then I can pass the order.
2 days.
For your good, I am saying, giving you all this advice and you are.
Yes. Date may be given.
Learned Counsel, Mr. N. Uddin, na,
Yes, ma'am.
has prayed for adjournment, send back the CD, call for the up-to-date CD. Learned Counsel, Mr. M. Islam. M. Islam is present for the respondent number 2. Learned Additional PP, Mr. B. Sharma is present. List this matter. You go to the statement and
Fine.
you'll see. After you go to the statement, you won't appear.
My lord.
I am blessed.
Appeal number 20 for orders.
Lordship, I beg to apologize, Lordship, I could not file the objection of the intellectual application.
We'll give you another date.
Yes, sir. In the meantime, we, after
Subject
this.
to his objection. You have
No.
any objection?
No.
Okay, he doesn't have objection also. Learned Counsel, Mr.
P. Bravo.
P. Braga is present. The duta club ko likhi diba, huh? Present for the applicant stroke petitioner. Learned counsel, Dr. B. N. Gogoi is present for respondent number 2 and has submitted for time to file objection. Learned additional PP, Mr. B. Sharma is present.
My-
Is this matter January?
Lordship, an attempt has been made for outside settlement if it will be placed on the record.
It is also submitted that there is every element of settlement between both the parties. List this matter.
On 28 January.
Okay.
Obliged.
Item 24.
May I please your lordship? Your lordship, as per office note dated 15/11/2025, steps have been taken upon respondent. Lordship. Lordship, and for the respondent, wife, lordship, we will file our reply, lordship. Okay. And also we will file our wakalat nama also. Lordship. So 4 weeks time may be run.
4 weeks time?
Sure.
Learned Counsel, Miss
RDB.
RDB is present on behalf of Learned Counsel,
S.
Mr.
Deori.
S. Deori.
Yes.
Learned Counsel, Miss
A. Sharma.
A. Sharma is present for respondent number 2
Yes, sir.
and has submitted that they will file wakalat nama on the next day fixed and has also submitted for time to file an objection.
Yes, Lord.
This matter January. After 4 weeks.
Much obliged.
Item 25.
May I please, your lordship, lordship, in this matter, we have taken steps today, lordship,
Okay.
in the morning, lordship.
Okay. Learned Counsel, Miss J. Ghosh.
Yunanda.
J. Ghosh, no?
Yunanda.
Yunanda. Learned Counsel, Miss Yunanda, on behalf of, your name is in the first list. Okay, on behalf of Learned Counsel, Mr. S.C. Biswas has submitted, they have taken steps. List this matter up to 3 weeks.
Yes, lordship. Any date may be given, lordship.
Okay, date of the deed of
on, it's 9 January.
9 January.
Oh, bless Lordship.
Item 26.
Wait, please. Lordship, this criminal petition has been filed seeking Jimma of the coal released by the police in connection with Lekhapani case number 32 of 2024. Earlier, this petitioner has approached this honorable court by filing a Jimma petition in connection with Lekhapani PS case number 35 of 2024.
Before my understanding, said, my lord, a report has been called for, my lord, but that report is not yet received from us. One report has come, my lord, but that is not proper, my lord. So, my lord, another report was called for, my lord. And your lordship can see the first order, my lord. This is,
Yes.
perhaps, my lord, investigation or my lord, agency, my lord.
Yes.
They confused, my lord. So they have stated a report from Lekhapani PS 35 of 24, my lord. So that has to be from 32 of 24. Same types of case, same coal.
This case has only because of the confusion, this case is, we have approached this honorable court.
Yeah.
Earlier, we approached this honorable court in Lekhapani PS 35 of 2024. Jimma was granted. We took the Jimma. Thereafter, we came to know from the IO that our part of our coal has been seized in 32 of 2024. As per Lordship, section 103 of C6, notice to the occupant order petitioner should be served with the note of the seizure list. We did not have knowledge. That's why we have again come before this, again approached the learned trial court. Our Jimma was rejected only because the Jimma was given to the Geology and Mining Department. Since we have already granted Jimma in 35 of 2024, now the part of the property has been seized in 32 of 2020. That's why we have approached this honorable court in connection with 32 of 2024.
No, no.
And regarding the report,
Regarding the merit part of what my learned friend is submitting, my lord, that will not be any fruitful at this stage, my lord, because at this stage,
We'll
one
need the report.
report and report as per the first report.
look into
Because
the
they
earlier orders
stated-
from last five
and
occasions.
and also my lord, lordship, they are protected.
Report I
No,
have.
report-
They are protected with a status quo order, my lord.
Yeah.
After the
Yes.
status quo order also, the coal was lifted from our premises. It has been
That
auctioned
is
also.
that is
But
a
even if the seizure itself is illegal, the whole consequential actions goes.
No.
But
Then
anyway,
when under status quo order, when it is violated, you cannot, you'll have to file an interlocutory
yes,
application.
if it is violated between the status quo, there is no petition as such, my
anyway,
lord.
but the
With supporting documents relating to, what did you say?
lifting
Auction.
of the
Yeah.
lifting of the coal and auction
you-
has been it's already reflected in the report by the IO, and the IO has himself stated in his report that the coal belongs to the petitioner, the present petitioner. Anyway,
No, you
Lordship,
see,
if the report is
dispose,
required,
I'll need
I am
a
not
report.
pressing it today, but Lordship may kindly indicate in the order, because from the last 6 occasions, Lordship
Okay,
may
learned
kindly
counsel, Mr.
H. Agarwal.
H. Agarwal is present for the petitioner. Learned additional PP, Mr. MP Goswami is present for the respondent state, full stop. A report, as called for is not forwarded. Call for a report relating to which case number.
My lord, you may kindly see the first order, my lord. That will clear the case. First order is because several orders have been passed, my lord.
19/8/2025.
Yes, my lord.
No,
There,
no, 4/8/2025.
yes, 15/7, my lord.
No, but we are
Twen-
concerned with this police, the 32.
28/7, your lordship may kindly see 28/7 order, last order, my lord. My first order, my lord.
Yes, yes.
Because whatever has happened, my lord, since this case at first, since I was the advocate, my lord, dealing with the case, but subsequently it came in different courts, my lord. So there is some confusion regarding what report, my lord. Your lordship may kindly, my lord, specify the report as per our first order, my lord, 15/7.
Call for a report, 15/7,
Yes, first case when it comes for motion, my lord,
28/7.
28/7, my lord.
Call for a report as
As
per
per-
order of this court dated 28/7/2025.
At this, on that day, status quo was given and order, that is what,
List this matter after vacation.
yes,
As it is, your coal has already been lifted and sold.
yes.
But Lordship, the
And they are-
petitioner
that is why
facing
state-
financial hardship, Lordship.
That is why status quo was given, my lord.
Coal was already in 35, Lordship. His documents was verified, and all his documents were verified by the GST department.
Short date,
Lordship.
is 30 days.
Lordship, on did they report, Lordship, because on the last 6 occasion, only for the report is
Positively লিখি দিয়া, positively without fail.
deeply applied.
Item 28.
May I please Lordship, I'm appearing on behalf of RB Bora, season election program. In this matter, Lordship, as per the office note dated 9/25, both LCR and service report is awaited. Okay.
Service report is awaited. Call for the issue reminder to forward the LCR. Scan copies of the LCR. List this matter immediately after the winter vacation.
Item number 1. Item number 5. Item 8. Hearing matter item 29.
This is a revision against conviction. And my lord, petitioner is convicted under section 143, 1B of the Railway Act. And my lord, sentenced to my lord SI for 2 months and fine of rupees 3,000, my lord. My lord, the appellate judgment starts from page 16, my lord. Against that appeal was preferred, appeal also dismissed, my lord. So after that, this revision, my lord. My lord,
So
altogether.
that sentence is upheld.
Yes, sir. Yes,
2 months sentence.
2
is
months and
upheld.
my lord, a fine of rupees 3,000, my lord.
You are a serviceman.
No, no serviceman.
Then we will reduce from only, okay.
No, there is a compulsory jail is there.
No, my lord, or fine, sentence or
Or
fine, or is there?
So the law.
No, I don't think
Or is there?
with fine, I think. Under section, which section?
143, 1B.
Yes, probably.
Or it is, or my
I
lord,
have forgotten.
either or.
It's been a long time. There's a railway. What is it? RPF Act, no?
No,
No,
Railways
no,
Act. Railways Act.
Railway Act.
Railways Act.
Because the fake ticket counter was sold out.
Is it out?
It out, my lord. Yes, fine can be imposed. Enhance it, madam.
Huh? No.
Fine can be.
Cannot be enhanced. It will be remain.
It can be enhanced because you will get a new judge, give a new judgment, madam.
For enhancement, then there has to be another petition for enhancement.
Probably not required, my lord, with all respect. Because
Not required. It's not required.
I'll not go for argument. I'll leave it to you, lordship. The old case, of course, no doubt.
143, 1B, my lord.
143, 1B, no? Where is the judgment and order?
My lord, the trial court.
Trial court judgment and order?
Page, it starts from page 10 and my lord, sentence will find lordship at page 15, my lord, 15.
Page 10, page 15.
Page 15 is the sentence part, my lord, 15.
143, 1B.
B. It is either or, no.
You're for the railways?
Yes.
Why do you want to make the railways rich?
I mean, my lord, it should be exemplary because there are so many
After 14 years.
14 years, he has not suffered, but he's enjoying. He has all along on bail, my lord.
Not 14 years, it will be 13 years.
13 years.
2000. Yes. 14 years.
14 years, my lord. It was 2012. 2011, my lord. Case was.
Or with fine?
Or with fine.
10,000 or with both?
Maximum is 10,000.
Revision petition, no?
Yes, ma'am.
Likha, judgment. Judgment and order oral. Third learned counsel, Mr.
A.K. Gupta, ma'am.
A.K. Gupta, for the
Petitioner.
petitioner, Sri Ashok Jha, who has filed his application under section 401, read with section 397 of the Code of Criminal Procedure, challenging the legality and propriety of the order dated 2002-2015 passed by the learned additional sessions judge -1, of course, session judge -1, within bracket FTC, bracket close, Tinsukia in criminal appeal number 9 within bracket 2, bracket close, stroke 2012, dismissing the appeal by upholding the judgment and order of the trial court, whereby the petitioner was convicted under section 143 within bracket 1 within bracket small b of the Railways Act 1989 within bracket the Act of 1989 for short bracket close, and sentencing him to undergo simple imprisonment for 2 months and to pay a fine of rupees 3,000 with default stipulation. Third, Mr. S.C. Biswas, learned.
Senior Special Counsel, Railway.
Senior Special
Counsel, Railway.
Counsel, Railways. Anybody else?
No, near.
For the respondent? For the respondent number 1 and 2.
Yes. The second one is he was the informant from Railway.
From the respondent number 1 and 2. The legality and propriety of the orders impugned has been challenged. Next prayer likh diyo. As both the courts have committed gross illegality and the orders of convict and orders are liable to be set aside. It is contended that the search and seizure was conducted in the absence of independent witnesses, which is bad in law. Most of the the railway tickets allegedly seized from the petitioner the railway tickets were allegedly seized from the petitioner in absence of independent witnesses, full stop. The courts below were inclined towards the submission of the prosecution. Full stop. It is contended that the prosecution failed to bring on record that the public present in the busy area were not willing to be witnesses to the seizure of the railway tickets. Full stop. The railway tickets were validly booked in the name of Sri Subhat Jha and B. Soikia, which was ignored by the prosecution as well as by the courts.
Okay.
Full stop. The extrajudicial confession was allegedly made in presence of police officer and which cannot be accepted as evidence.
Revision criminal. Give us the conviction. Dari. Aje look at regular. Relay, no?
The courts have failed to appreciate that the petitioner had no previous criminal antecedent and he was entitled to be released on probation. Full stop. Per contra, the learned special senior what? Learned counsel for the railways, no?
Railway.
Per contra, the learned counsel for the railways has submitted that there is no infirmity in the judgment and order passed by the courts below. In the orders passed by the courts below. No, passed by the courts below, no. Orders impugned by the petitioner. Full stop. The petitioner was caught red-handed while selling railway tickets illegally. Full stop. The petitioner is liable to be punished under law and a lenient sentence was passed by the trial court. Full stop. The genesis of the case was that on 5/1/2011 at about 8:10 hours, when the constable Ananda Dole was on duty at JTTN station, he apprehended a suspected tout at Jorhat PRS and thereafter informed the matter to the complainant, namely Subhan Hazarika, ASI, RPF, within bracket OP bracket close, JTTN, full stop. The complainant, Subhan Hazarika, respondent number 2, rushed to the spot and nabbed the petitioner along with 2 computerized tickets which were found in his possession. Full stop. On being confronted, the petitioner could not give any satisfactory reply for purchasing those tickets. Full stop. He was immediately arrested and the tickets were seized. And the petitioner was produced before the IPF, MXN, capital the present case was registered as RPF/POST/MXN case number 2/2011 under section 143 of the Railways Act. Full stop. Investigation comments and witnesses were examined and finally charged sheet. Offense report or charge sheet in this case?
Yes.
Offense report.
Offensive. Offense report.
Offense report. And finally,
Offense report was submitted.
offense report was submitted. Full stop. During trial,
Four witnesses were examined.
Huh?
Four
The-
witnesses.
The complainant, during trial, in 4 witnesses, including the complainant, was examined.
Accused did not adduce any evidence.
Whereas the accused did not tender any evidence in defense. Full stop. His statement.
313.
His statements were recorded under section 313 CRPC and his plea was of total denial. Full stop. The evidence of the, that was the, who nasile Ananda Dole constable, na?
Yeah. ASI, ma'am.
ASI.
Constable.
Constable.
During evidence, the evidence of the constable who caught the, who caught the petitioner selling, or who caught the petitioner, no, who caught the petitioner? The evidence of the constable Ananda Dole, SPW1,
Ananda Dala is PW2, ma'am.
or SPW2, and the evidence of the informant, SPW1,
One.
clearly depicts that on 5/1/2011, at about 8 p.m.
8 AM, ma'am.
8 a.m., the petitioner was called, or the petitioner was found selling two Tatkal Seva railway reservation tickets. Petitioner was found in possession of two Tatkal Seva railway reservation tickets. Full stop. On being confronted, he could not give satisfactory replies, and then the PW1 was informed, who rushed to the spot and found the tickets in the possession of the petitioner. Full stop. The tickets were one ticket was from Dibrugarh to Delhi and the other ticket was from Guwahati to Delhi. Those of these tickets were seized, but there were no independent witnesses as the public, as not a single person from the public were willing to be witness to the seizure of the tickets. Full stop. APRS staff Siddharth Borua, PW3 was present during the seizure of the railway tickets. So he affixed his signature on the requisition forms of the requisition forms will लिखित ले हो जाबो. A separate seizure next pair लिखा. PW1 and PW2 further deposed that now PW1 and PW2 further deposed on. In addition, PW1 deposed that next pair लिख दिया. he arrested the petitioner and forwarded him to the RPF post. And he submitted a written complaint before the inspector RPF. Full stop. The inquiry officer recorded his statement. Full stop. PW1 has proved the written complaint as Exhibit 1 and his signature on the complaint as Exhibit 1-1. He has proved the seizure list as Exhibit 2 and 3 and his signatures on the seizure list as Exhibit 2-1 and 3-1. Full stop. He has identified Exhibit 2-2 as the signature of the petitioner, and the material exhibit N nalage, full stop here, comma nalage. He has identified the material exhibit 1 and 2 as the PNR of the seized tickets, capital PNR, and the material exhibit 3 and 4 as the requisition forms of the seized tickets. Both the witnesses PW1 and 2 were cross-examined, but no contradictions as per section 162, as per section 145 of the Indian Evidence Act 1872 within bracket the Evidence Act for short bracket close QUA, section 162 of the CRPC of the Code of Criminal Procedure or the Code of Criminal Procedure within bracket CRPC for short could be elicited through the strenuous cross-examinations of the witnesses. Full stop. The evidence of PW3 also corroborates the evidence of PW1 and 2. Full stop. He was serving as head inquiry cum reservation clerk at the time of the incident. He has testified that on 5/1/2009 at about 8:15 to 8:30 hours, an RPF personnel apprehended the petitioner and the petitioner was produced before him. The petitioner was found in possession of 2 railway tickets by the RPF personnel, PERSONELL. One ticket was from Dibrugarh to Delhi and the other was from Guwahati to Delhi. The tickets were not in the name of the petitioner but in the name of some unknown individuals. Full stop. Those tickets were seized. And he has identified his signatures as Exhibit 2, 4 and 3 on the seizure list. Next prayer, Lika. The inquiry officer Vinit Kumar deposed as PW4 that on the day of the incident, the PW1. I'll come back and pass the order.
Item 34, vote to be fixed, my lord, for hearing. 34. So, my lord, so I'm not feeling well, so can it be?
Yes, this is the new case, can give adjournment.
Lordship?
Can give adjournment, new case, 2024.
Only 2 months conviction, is there 1.5 months, I think she was inside the jail at the initial time, Lordship. So, on reopening, my lord, if.
Yes. Learned Counsel Miss S.K. Nargis has prayed for adjournment, list the matter application of 20 January or later?
20 January.
20 January, okay.
May I please your lordship?
Okay.
My
Obliged,
Item,
lordship.
item 30, 31. 32, my lord.
31, 32.
In this matter, your lordship, I am for the wife petitioner for enhancement of the maintenance, my lord, long pending and fixed for hearing. I have filed an affidavit, it doesn't come on record, my lord. So, my lord, it may come, my lord, on Thursday next, my lord, if possible, my lord, very
No.
urgent otherwise.
No hearing on next week.
No hearing, my lord, then on reopening immediately, my lord.
Yes,
My
reopen.
lord, might be on 6th, my lord, Tuesday, my lord.
On?
6th, my lord.
Oh, yes, fine.
My lord, Tuesday, my lord, hearing.
Yes, yes. Learned Counsel Mr.
A.K. Talukdar, my lord.
A.K. Talukdar has prayed for adjournment and has submitted that the
Affidavit, my lord.
respondent
My lord, I am the wife petitioner, my lord.
that the why that an affidavit has been submitted on behalf of the wife.
Which is not on record, my lord.
Receipt to place this affidavit on record. List this matter on 6 January. Do you tell Same case?
Same, my lord.
Okay.
In item 32, interim order is there, that may be called.
32 liquidation interim order shall remain in force till the next date of listing.
Okay.
32 data addition koriba.
Yes.
Learned Counsel Mr. A. Ahmed, no?
Lordship. Lordship.
A. Ahmed is present for husband,
Lordship.
for the husband.
Okay.
Lordship.
The order
ma'am.
will be passed. You see,
Yeah.
I will admit it, but you see, I will not stay anything. You see that petition against which you are aggrieved, that petition is not in the record.
So, my lord, kindly stay the execution proceeding, my lord, not that order, my lord. Execution is going on, but proceeding is still, well, that may be.
Why don't you want to pay?
No, my lord, because he is the censor, because another case is now going on in that civil court Tezpur, in between their legal, regarding the legal here, my lord. That means he is not the person who get the payment, my
But the
lord.
wife is alive, no?
Yes, my lord.
The wife is alive.
Wife, no, wife is already expired, my lord. That is the case, actually.
Wife has already expired.
Wife expired, he is the son. That is the person Ghanshyam Dhiman. He is one of the son of the wife of, son of that main proprietor of that GD Engineering. So they have another sibling also. So now
Cannot be stayed. Cannot be stayed. But I'll fix a short date.
the execution, my lord, only execution proceeding, my lord, not that arbitration. I am not going to say that arbitration, my lord, order, but at least execution proceeding may stay, my lord. Only that part, my lord. Arbitration, my lord.
Cannot. I'm really sorry.
Yes,
You
ma'am.
see,
Admit, madam.
even to consider that petition,
Yes.
should I bring the, will you annex the petition? That petition will be required.
Yes, then I'll
You see,
file one
you are-
additional affidavit, my
You are
lord.
agreed by the petition.
Yes, my lord.
You are agreed by the petition, but the petition is not in the record.
Not in the. Then, my lord, I'll bring it by filing an
Last
additional.
time when I asked you, both of you told me that you do not want the records. Records are not required. But the petition you are agreed
Yes,
by,
yes.
and the decision was on the petition.
Yes, my lord.
One copy is also not in the
Yes,
record.
but then I'll file it by filing an additional affidavit, my lord, being on record. But I'm going to admit that appeal, no, my lord.
I'll admit it.
Yes,
I'll
ma'am.
fix it for hearing.
Yes, ma'am. Then.
I'll admit it.
Yep.
Can be admitted. There are judgments both ways.
Yes.
The limitation thing.
Yes.
There are judgments on both sides.
Limitation apply in the arbitration proceeding. There is a judgment. That is.
There is a
There is
judgment, but you
nothing.
haven't given supporting
No,
judgment.
my lord, there is the Supreme Court did not say anything regarding the limitation part, and limitation applies in that arbitration proceeding 1940 cases.
There are
Limitation
judgments,
is
but
applied.
you did not give me any supporting
Yes,
judgment.
Then
So it
admit
was
it and
difficult. I could have disposed it, but that petition
Yes.
is not there.
Yes,
Without
then
the
I'll file
petition,
it by filing additional affidavit, my lord.
we'll admit the appeal
Yes,
for
ma'am.
hearing.
Then it's okay.
For hearing short date, no.
Short date,
Short
ma'am.
date, yes.
Yes, ma'am.
When do you want? You tell me.
Well, after vacation.
Where is the other party?
I don't know, ma'am.
You see that 1 crore 33 lakhs contract was done. You are not willing to pay. Why?
My lord, because I'm
Maybe 3 lakhs or 4 lakhs, there may be a dispute, but that
One
But
crore
my lord,
33 lakhs
but
from
in-
1992.
But in this case, my lord, he is censored. That is our main, because wife was alive at that time. Wife did not give any power of attorney to the to his son to go for the arbitration proceeding, and he is not elected to in each of the, neither in the contract nor in that proceeding also, my lord. That is main issue actually, my lord. And this is not only one case of my lord, actually, my lord, this is not only one case of his in their department. There are lots of cases pending, my lord. That is the main reason actually.
Okay, short
Yeah.
date is a DD.
Some-
It will be better if I give a short date because 1 crore 33 lakh.
Yes, ma'am.
Class 1 legal heirs deserve it.
Yes, ma'am.
Class 1 legal heirs will get it.
Yes, class 1 legal will get it, madam.
He's
But
not the
that-
class 1
but-
legal heir. No. How?
No, case is going on before the.
He's not the class 1 legal heir.
Yes, my lord.
He's not the class 1 legal heir.
He
of
is
the-
class 1, there is another class 1 legal year also, my lord.
Okay, maybe done.
And case is also going on in the test.
নাই নাই
voting.
তহঁতি অকমান আগত দি দিয়ক 1 crore পইচা
Yes,
কথা
ma'am.
আছে আৰু that too
Yes, madam, it's okay.
years. And then interest 9%, it will become. I think-
Yes, man, it will become more than that main.
Yes, why you're taking the risk?
My department is taking that.
Okay.
Must have like that.
Only because of that petition,
Yes, madam.
I was toiled around for so many days and I
If
wrote
it
the
is-
dictated the
before-
judgment and then the main petition is not
Before
there.
vacation, I'll file it, madam, by editing
It
it
will
in
come
another.
before another court maybe,
Yes, madam.
later. Okay.
Must have.
Last sentence to কি আছে? ইমানে আছে? PW1 lodged a written complaint. I.e. Exhibit 1. এইটো লিখিছানে? নাই লিখা? And on the basis of the complaint, a case was registered by RPF stroke POST stroke MXN, case number 2 stroke 2011 under section 143 of the Railways Act against the petitioner. And he was endorsed to conduct the inquiry and submit prosecution report. First off, he recorded the statements of the witnesses as well as the petitioner. First off, he has also stated that during the inquiry, he could unearth antecedent of the petitioner who was involved in a similar case. Number 14/2010 under section 143 of the Railways Act. On 13/12/2010 and on 13/12/2010, the petitioner was convicted and sentenced in the said case. Full stop. So
Yes, my lord.
antecedent, then he will have a higher punishment.
My lord, he was earlier, he has, in that case, he has pleaded guilty, my lord.
Hmm.
So lordship may enhance the fine, my lord, my submission.
Can enhance the fine.
Yes, my lord. Maximum is 10,000, my lord, I leave to your lordship, my lord.
Where is the revision? Let me see. For petition under section 430,
401, my lord.
401. Next paragraph. PW four further testified that he submitted the prosecution report under section 143 of the Railways Act against the petitioner. He has identified the statement of the petitioner as exhibit 4 and he has proved his signature on exhibit 4 as exhibit 4.1. He has identified the prosecution report as exhibit 5 and his signature on exhibit 5 as exhibit 5.1 within bracket 112. The witnesses were cross-examined in extenso, but no contradictions could be elicited through the cross-examination of the witnesses under section 145 of the Evidence Act vis-a-vis section 162 of the CRPC. Full stop. On the uncontroverted evidence, the trial court arrived at a decision which warrants no interference, and the learned appellate court was correct in upholding the decision of the learned trial court. In criminal appeal by order dated 20/02/2015 in criminal appeal number 9 within bracket 2 of 2012. Now, what is the age of the petitioner?
My lord, he is
No infirmity is deducible from no infirmity is discernible on the decision of the learned trial court by judgment and order dated 33/2012 in SRCR case number 36 of 2011.
about 35 years, my lord.
35 years. It is submitted that the petitioner is 35 years old and he has a family to take care and he has a family to tend to tend to. First off, he is the sole breadwinner of his family.
He is working as a daily wage earner, my lord.
First off, he is a daily wage earner and he is forwarded to custody. He may suffer irreparable loss. Full stop. I have considered the submissions that much water has flowed under the bridge. Full stop. The impugned judgment of the trial court was passed in the year 2012 and the judgment of the appellate court was passed in the year 2015. The conviction under section 143 of the Railways Act may extend to 3 years and 3 years is imprisonment which may extend to 3 years or fine which may extend to 10,000 rupees. In the wake of the foregoing discussions, it is held that the appeal is dismissed as, and the judgment and order dated 2015 in criminal appeal number 92 of 2012, and the judgment and order dated 33/2012 in no, and the order of conviction dated judgment and order dated, no, order of conviction dated and the order of conviction dated 33/2012 in SRCR case number 36 of 2011 is upheld, but the sentence is scaled down to the has he been behind bars for any day?
That I'm not sure, my lord.
Okay.
But he was arrested for some few
The
days.
sentence is scaled down to only only fine, whereas the sentence, whereas the order of custodial sentence of 2 months is set off. No, scale down
Maybe
লিখে দিলে হবে।
Set aside.
No, not set aside. Appeal is
Only
dismissed.
sentence part, my lord.
Hmm?
Sentence part, lordship may set aside fine.
Appeal is partly allowed to করলে ভালো হবে, dismiss না
Yes,
করলে।
ma'am.
Appeal is partly allowed, and order is scaled down to the to a sentence of fine only, full stop, and the order of custody, order of sentence of imprisonment for 2 months is set aside, full stop. The petitioner is directed to pay rupees 10,000, or the petitioner is convicted under section 143A of the
1B, 143,
1B, 143, 1 small b of the Railways Act, and sentenced to a fine of rupees 10,000 and in default of payment of fine to undergo regular imprisonment for 3 months, full stop. The petitioner is directed to pay the fine before the learned trial court within 1 month from the
Let it be 2 months, my lord.
Huh?
Let it be 2 months, my lord, because
within 2 months from the date of this order, send back the original records of the of SRCI case number 36 of 2011 and criminal appeal number 92 of 2012 immediately.
obligation.
Time being item 1.
It will লিখি not represented বুলি তিনিবাৰ মতা হল না
Number 1.
আছে
Item 2.
May I please, your lordship? Lordship, I have alternate prayer is also there in my petition, lordship.
wait
Right. Page number 6 of my application.
ৰাতিপুৱা কোন বহিছিলে তুমি আছিলা ডিক্টেশনটো ললা
Page number 6, lordship. Right. And or enlarging the applicant on face bail, lordship.
Okay. এইটো কিমান লাগে লিখিলা লাষ্ট সেন্টেন্সটো পঢ়াচোন or to pass an order directing the petitioner to be enlarged on fresh bail. I have considered the submissions at the bar, full stop. The petitioner is hereby enlarged on bail of rupees 10,000 with a suitable surety of like amount to the satisfaction of the learned trial court, who may impose appropriate conditions if the court deems fit and proper. To stop the operation of the order of conviction and sentence dated 4/7/2025 passed by the session judge in criminal appeal number 15/2025 and the operation of the order of conviction and sentence dated 13/3/2025 passed by the learned chief judicial magistrate Udalguri in PRC number 426 of 2022 is hereby stayed on it further orders. In terms of the above observation, this application stands disposed of. Criminal petition, it will issue notice. Criminal petition, petitioner to take steps to issue notice returnable within 4 weeks.
Deeply obliged, deeply obliged.
Item
Your Lordship, the engaged counsel is on legs on 24, Your Lordship. The matter is already started. A little later, can it be taken? Can it be taken up after a little time?
After?
A little time. Your
Okay,
Lordship.
yes, then I-
Item 5.
Might be lost. But sometime we have to go other course, so I cannot attend timely.
No, it's okay.
Oh, my.
No problem.
But here is a case, one Mr. M.M. Sokka, retired district judge, Your Lordship might have known, my lord.
I haven't met him.
Yes, long back, my lord. He died in 1923 at the age of 89 years, my lord. So he had, my lord, one child, one. Yes.
From Silchar?
No, no, no.
Koimganj?
Dhubri,
Dhubri.
So one sister, one brother, my lord. So regarding land, my lord, the son has mutated his share, and that was sold to a petition number 2. Now the question has come, one offense they have committed, my lord, that they have third person, some Wasim, who is not petitioner here, my lord. He applied in the name of that Mr. M.M. Sokka, retired district judge, after his death, 4 days after his death, applied for mutation. So that mutation already cancelled, this order was all there, my lord. It has gone to Revenue Board. Revenue Board also said it is a civil matter. They have come here for bail, my lord. This court, honorable court passed bail order saying that it is civil matter, my lord. Now this FIR we have come for quashing, my lord, only this one. So the basic cases, my lord, regarding mutation without the knowledge of the other Pattadas, my lord, and family members. Informant is the brother of the late district judge, my lord. And the accused are the son of the late district judge, my lord.
Both their case?
No, that's number 1.
Number 1. Number 2 is the person who purchased the land for number 1. He is a doctor, my lord, professional government doctor. And number 1 is a UD assistant, my lord. Both are employees, my lord. So, my lord, we have made party also. Other one informant we made party also, my lord. Well, let the notice go in the meantime, my lord, because both are everything, everywhere it is state in civil matter, my lord.
Yes, yes.
So this is my humble prayer, my lord.
After investigation, police has found materials and charged it.
Yes, yes. Cognizance also taken.
Into the petition, and after receipt of the petition, Lordship may consider their interim judgment. And in the meantime, notice may be issued.
That I leave to your lordship.
Miralkanti Sokka? Who is Miralkanti Sokka?
Informant. Who is my uncle. My uncle means brother of the retired district judge.
Okay.
And I am the son of that, my lord, that year.
Some disputes are.
Yes, land dispute, everywhere it is a civil. My your lordship, I take your lordship to bail order, my lord, also. Bail order also it is clear, my lord.
The receipt of petition, Lordship may consider to decline judgment.
Page 40? Page 44. Here you got observation, Revenue Board of Asin. Page 45, my lord, your lordship. It is our submission was civil, then accused has call for the record. Then that is hit to page observation. Revenue Board not then page 43, my lord, observation of the court below, my lord.
Made absolute, no?
Yes, that's made absolute. They are on bail, my lord, only because unnecessary, but ultimately it is not a case for my conviction, my lord. That is, I am on that. Purely civil matter, family matters, my lord. Ultimately, it will be settled also, maybe. I think so. They are educated family, my lord, both are. I think somebody will prevail upon them, my lord. And page, what was it?
Page 35, ma'am.
No, 35. 42.
Second parameter, allegation of using some fake documents, my lord. Thereafter, against Raja Sokka, my lord, your Lordship may kindly close. Again on 21/2024, my lord. A person namely Abdul Rahman applied for a transfer of the land dated so and so, in the name of Raja Sarkar and daughter Mohila Sarkar of his dead brother. After that, in short time of period so and so, land in the name of dead brother had been mutated in the name of
Yes.
Raja Sarkar.
His portion.
Only his
Okay.
portion.
Pass an order later.
His portion
I'll
was
give
madam.
pass an
I
order.
think his portion, madam. Mutations are in his portion. It is true that procedure has not been followed. But only one line, page 43, madam. One just page 40.
Mutation of what?
Now, observation of the district commissioner, madam. Page 43. On perusal, your page 43, middle portion, my lord. On perusal, your lordship. On perusal of the adduced material facts and circumstances, and I am of the considered opinion that the above matter is civil in nature.
But a forging document?
My lord,
No, that not forged document in that sense, but the only thing is I am confined to only my part, madam. Whether I will find anything.
Person has died, if he will say that he is alive and sell the land.
No, ultimately, madam, my question, madam, whether the mutation was done
Pass an order.
beyond my property or not. I said in respect to my share only I have. Only partition was not made, this is the true, madam. Without partition, I made in respect of my share only, madam.
I'll pass an order.
Obliged to us.
Did you order? But
Only Bojanlal, madam, ultimately what will happen?
I will issue notice. I'll issue notice.
That is your lordship, madam, your lordship.
But you want to stay, so I'll.
But you will kindly see, madam. That we have.
Case and then I'll.
That certainly your lordship will do justice, madam. Many matters, my lord.
I'll try.
Obliged.
Justice, definitely I'll try, but I don't know what you call justice.
Item 1.
But I'm sorry, my lord. Two items were fixed at 2 before
It's
court
okay.
number 24, my lord.
As long as you don't pay for interim stay.
My lord, by this criminal revision petition, my lord, we have challenged, my lord, the final order dated 29/8/2025, passed by the Principal Judge Family Court, Borpeta. The proceeding was under 125 CRPC, my lord. Now, I have also filed an additional affidavit, my lord. Perhaps it is on record.
125.
125 CRPC.
Your husband,
Husband, my lord.
you want to reduce the amount.
No, no, no.
You do not want to pay at all.
No, the thing only our main ground is that, my lord, the affidavit regarding the assets and liability, I filed, but the wife did not file. Petitioner did not file. And without taking that into consideration, the quantum was fixed. On merit, I'm not going to submit because I admittedly she is the wife. So that's not disputed. The only dispute is regarding fixation of the quantum. Now, lordship will kindly see the additional affidavit, my lord. The petitioner, my lord, he is working as a Latmondon. His salary is around 41,000. So that we have disclosed in the assets and liabilities affidavit. Now, what happened was that, lordship may kindly see page number 57. 57 of the additional affidavit. The petitioner, my lord, was arrested in vigilance PS case 25/20/2025. So he was in detention for a period of 2 months. After that, he was granted bail. But by that time, he was already suspended. So right now, he is not receiving any salary.
No, he will receive 20,000.
But he is not receiving any salary. That is the present status. Now the thing is that the executing court is saying that you will have to pay the balance because during the final order, it was said that you have to pay the amounts from the date of filing. So the balance amount, if your lordship will kindly see the last order at page number 60. Para number 2, the court below has said that you have to deposit the balance amount of 1.5 lakhs. On the first day, we deposited 50,000 and the NBWS recall. Now, what has been said is that tomorrow, that is 12/12,
has been fixed for payment of the balance amount, that is 1 lakh. Now, at this stage, my lord, we cannot pay that 1 lakh, my lord. Now, we are ready to pay the normal monthly maintenance, we are ready and willing to pay that. That's not problem. But regarding the balance amount, that may not be considered because admittedly, my lord, the assets and liability affidavit was not even filed. And without that, my lord, the quantum was